unintentional tax errors, including not alerting SARS of changes to your personal details or failing to keep records from previous years, could see you get a fine or land in jail. It comes as amendments to tax legislation scraps the concept of intention from certain offences. This means prosecutors don't have to prove that you willfully broke the law, and the court can find you guilty of an offence even if you were just being negligent. We're joined now by the SARS Commissioner, Keyswetter. Commissioner Keyswetter, certainly a superficial reading of these changes, I think, would have any taxpayer shaking in their shoes, because the risk of facing jail time for what would ordinarily be considered maybe a small mistake won't be the case going forward.
Kathy, yes. So the first clarification that I need to give is that this is not a new concept in law. We are simply regularizing a principle in law that existed before 2011, and when the 2011 Tax Administration Act was written, this was not included. So it's just rectifying that. The second point is that, we always think of ourselves as unique in the world, but you'd be very glad to hear that this is an international practice. Other countries like Australia, Canada, New Zealand, they all use the principle that intent is not required. Now, let me get to the specific logic or rationale behind this. This is not a license for SARS to throw anyone in jail who for any reason does not fulfill an obligation such as it may generally be claimed. The first reason is that the state must still prove what is known as blameworthiness. And blameworthiness has to be proven beyond reasonable doubt based on one of two principles. The first is a principle of negligence. In other words, you have knowledge of it, but for some reason you ignored to apply the knowledge, which is a fairly objective criteria. And the second one is intent, which means that you actually chose intentionally to ignore application of the law, which is more subjective and quite frankly harder to prove, even though the consequence of the omission is the same. So the point I'm making here is it's not a free-for-all for SARS. The state will still have to prove blameworthiness. Now, if I use an example, maybe it'll clarify it. If you go down the highway, as you would never do, because you're a very law-abiding citizen, and you travel at 145 kilometers in a 120 zone, it doesn't matter whether you did so with intent or whether you just did so negligently. You will be fined, and you will have to pay an admission of guilt if it is within the framework and beyond a particular speed. I think it's 150 kilometers, I'm not sure. There is no option to pay an admission of guilt. You will have to appear in court. And intention is not a criteria for blameworthiness. You may, of course, say, well, you rushed, you sped on the highway because you had a medical emergency that you had to attend to. And that would obviously be taken into account in terms of establishing blameworthiness. By the same token, if you fail to submit a return, or you fail to disclose information that you ought to disclose, you may say, I was out of the country, I traveled, and by the way, I did try to log on and I couldn't for the following reasons. And if you can establish that you actually did try, then a certain amount of blameworthiness would then, you would argue that you weren't blameworthy. So I think that's very important, that the context of this law has to be understood by all taxpayers.
So
and then I think important...
Sure, go ahead, Commissioner.
No, I think then what is also important is in our approach, when we announced our strategic intent, we established three things that we will always do, and specifically in this order. The first is we will continue to provide clarity and certainty to taxpayers of their obligations, and we do so through practice notes, through interpretation notes. Taxpayers can come to us beforehand and seek clarity. So clarity and certainty is an important principle when we administer our law. The second is we will always make it easy, and I know some taxpayers still may say they have frustrations, but generally we are working hard at making it easier for taxpayers to fulfill their obligation. And then the third strategic objective of SARS is to say, if we detect non-compliance for any reason, whether it is negligently or with intent, we will then respond appropriately using all of the instruments in law. So we do believe our approach is not to catch our taxpayers doing something wrong, but always to assist them to do the right thing.
What happens in the case where a taxpayer needs to make corrections? This is to information that they've submitted in documents already. Does that mean that there's going to be a fine associated with those corrections?
So when a taxpayer submits a return, and hopefully increasingly online these days, there is a provision for a correction to be submitted to SARS within a specified period. But also, if SARS raises an assessment and the taxpayer wishes to raise an objection, they may do so. After the assessment is raised, there is generally a period of prescription. SARS cannot come back to you after the period of prescription has transpired and reassess you on the same information. There is only a provision in law when you have, for any reason, not disclosed the information, then we can go back as far as 10, 20, or 30 years to revise an assessment. And in the case where we would revise an assessment, then there would also be the time value of money that would be adjusted. Under certain circumstances, and again, this is the degree of blameworthiness and intent, SARS could also impose what we know as penalty interest. So there's two kinds of interest. The one is just the time value of money interest. In other words, you owed us 100 Rand 10 years ago. We multiply that by the interest rate of what it would be today, and you would pay that. And in the second consideration would be a penalty interest if we consider that you actually, with intent, chose not to disclose or not to include information. We believe that the law is very fair and that we will always create the opportunity for a taxpayer to explain to us why they find themselves in a position that they do.
And just before I let you go, Commissioner Keyswetter, let's talk about this latest suggestion coming through from the Davis Committee about empowering SARS and giving you more prosecuting powers. Have you had an opportunity to reflect on that suggestion and what it would mean for the organization going forward?
So firstly, this, we have discussed this, but this will come as a formal recommendation from the Davis Tax Committee. When the judge spoke earlier this week, it was wearing his hat as the chairman of the committee. We will obviously also consider that. Let me just share with you what has happened in the past is that SARS in the past did prosecute or at least fund the prosecution of certain matters when they considered it to be in their interest, and it was not necessarily a priority for the prosecuting authority. The important point to note, though, is SARS may not choose that a matter has to be prosecuted. That still remains the domain of the National Prosecuting Authority. But once a matter has prima facie evidence that it can be prosecuted, what Judge Davis is suggesting is that SARS, who in any event does a lot of the work, so SARS has its own criminal investigation department. It also employs people who have prosecution skills. It would be, what he is proposing is that when SARS have done the work, ordinarily we would have to hand over to the prosecuting authority what we call a court-ready file. and there is an inordinate amount of work that has to be done. And often in the bigger